Hi friends, if there is any income tax demand, assessment order, and the assessee has to pay the tax. So in that case, section 220 that specifies that when the assessee may be in a default. So assessee may be in a default when when there is a uh, dispute of tax demand and the assessee has received the notices under section 156. So that's a demand of notice to pay the tax within 30 days, and if the payment is not done within the 30 days, yeah, then in that case assessee may be treated as a in default. However, Section 220, subsection 6 of the Income Tax Act, that provides that if the assessee has filed the appeal, then in that case, the assessing officer has the discretionary authority to keep the demand in abeyance if all if the certain conditions are fulfilled or met. Now the question is that Mayor filing the appeal before the appellate authority will automatically grant the stay of demand. That does not will automatically grant the stay of demand. So the assessee has to apply for a stay of demand application before the assessing officer, and it is a discretionary power of the assessing officer after considering all the facts and the situations of the assessee may grant the stay of demand, but for this purpose it has to make the applications. So definitely there will be a applications that is to be filed before the assessing officer to stay of demand. Now the questions, what will be the consequence of the default in assessing? So in this situation there will be interest. So 1 month 1% per month there will be interest. Then there will be a penalty, and after penalty there will be a search, and there will be a seizure and attachment. So seizure and attachment, that ITU can attach the provisionally the property that belong to the assessee, and as well as there will be a first interest, then the penalty, and then the attachment, and there will be a prosecution. So thank you.